Hi guys, it's Kathy. I hope you're doing well. So for a while now, I've been saying clear your calendar for Monday, and I'm about to give you a preview of what we're doing on Monday. And so is my dog. And the reason why I can wait until Monday or whenever I want to is because you can only see this here. I'm the only one who has it. And it's great. And it's so good. And what I'm showing you here is absolutely nothing. The whole thing is like this and worse. And there's so many twists and turns in this whole long, long, long story that, I mean, I can't tell you what we're here for right now. Just watch. Just watch the preview and you'll understand what we're going to do on Monday. And it's going to be so much fun.
Mr. Kelly, we had several phone conversations in an attempt to resolve this matter, correct?
Objection, Your Honor. Discussions of settlement are not relevant and they can't be brought up in this courtroom.
He didn't ask you about what the terms of that settlement was. He asked you.
Yes.
And we discussed discovery and other matters in the process of that, didn't we?
Yes.
Okay.
And I specifically told you that they hadn't provided any discovery to date.
You understand that I wasn't the attorney for the vaster majority of that.
Yeah, I understand that. But you mailed to me, you hand delivered to me responses to my second responses, but you didn't file them with the clerk. They're not in the clerk's record. The clerk provided me with a complete record last week. It's right there, and there's no response from you. There's nothing in there from you in this case. So you did not submit the documents to the clerk of the court. You gave them to me at the jail. You hand delivered them, but you did not file them with the clerk of the court according to that record there.
All right. But you don't dispute that you had the response. You
I
didn't
did
like
have the response, yes.
But you got it.
Can you prove what was in those responses?
You don't get to ask questions, Mr. Kelly. You've already had your time with Mr. Harrington on the stand. You respond.
Yep, you heard that right. He called the lawyer. He called our lawyer up. And that's his ex-girlfriend. And questioned him. Yep, and we get to see it. It was before this.
Respond to questions when you're sitting in that chair.
Objection.
Do we understand each other?
Objection.
What's the
To
objection?
the relevance of his question.
The relevance of the question you've already answered.
This line of questioning, what's your next question, Mr. Harrington?
May I go forward, John?
You may.
And did I have discovery here at the hearing, although you didn't like it and objected to it? Did I have the discovery at the hearing for your use if you wanted it?
Do you have proof of that? No, I don't have any evidence that you had it available to me. No, sir, I don't.
Do you not recall that I pulled the thumb drive out and plugged it into the computer and started showing you such evidence?
An audio recording was the only thing that that was about.
And you stopped any further processing of that. Is that correct?
About that audio, yes, because I was objecting to you introducing that piece of evidence into court. I wasn't objecting the relevance of that audio recording was whether or not you were going to be able to introduce it into evidence. You never said to me, here's the discovery you requested, Mr. Kelly. It's available. You never told me the rest of your discovery is right here on this thumb drive if you need it, or would you like to review it, Mr. Kelly? You never said that. You tried to imply that you did, and you keep doing it, and you didn't do it.
Mr. Kelly, your voice. Please lower it. There's no need to be pointing your finger at Mr. Harrington either.
Mr. Kelly, did you subpoena those video records from us to appear at court with them?
Yes, and she produced a doctored rendering of that audio.
So what you requested was presented for the court and you chose not to listen to all of it.
No, sir, that's not what happened. What happened was my second request for production of documents, you responded to. That's not what you're talking about a subpoena. We're not talking about the subpoena anymore. We're talking about your failure to respond adequately to the production of records pursuant to the rules of the court and the discovery in the Civil Practices Act. We're not talking about the subpoena anymore, Mr. Harrington.
Are you through? I don't wish to interrupt you. Did you file any motion to compel on the second set of discovery requests that you're citing today?
I had no opportunity to. I did vocally ask the judge or object to your. At what point in time you provided me the discovery on the Friday before the Monday hearing? At what point in time would I have had an opportunity to file a motion to compel your untimely responses, your untimely and deficient responses?
You received those within the 30 days that you had requested. You received my response, whether you agree with it or not, you received my responses to that within the 30 days.
No, sir. You delivered your responses to me on December 6th, and my motion for those requests for those discovery was on November 3rd, outside of 30 days.
You understand that when you file these things, they have to be transmitted to me. Are you not knowledgeable about the 3-day rule? If you aren't, that's fine.
I know the 3-second rule. Oh, wait, 5-second rule.
Your client made no meaningful effort.
Respond to the question that's posed.
No, I'm not familiar with the 3-day rule.
Okay. Did you ask this court that day to continue that final hearing because of that?
Yes, I did. I objected to this court, that hearing being proceeded on the fact that she had not produced any evidence whatsoever. And you just shook your head and you denied my motion to compel her to produce evidence. I sure did. I had 3 pages of objections to her failure to produce evidence. Pages of evidence of her failing to produce
Mr.
evidence.
Kelly, you need to calm down.
Did you ask for an extension of time for discovery, or are you aware that there's a general rule that you file discovery within 6 months of the initiation of the responsive pleadings?
Oh, I'm 100% clear on that. Judge Caulfield failed to enforce the rules of the court and failed to enforce in 30 days as the rules of the court require. The rules of the court require him to rule on motions within 30 days in this county. He let things languish for 7-8 months before he would rule on them. So no, every meaningful effort that I made for a month, I tried to compel her through good faith contact, good faith discussion, asking her and her attorney to let's talk this out, let's get this done. And when they failed, I filed a motion for a hearing for a pre-conference discovery conference that you ignored for 6 months. So I was following the rules of evidence. I was following the rules of discovery. Cindy Hetzer, James Rockefeller, and James Caulfield were not.
Mr. Kelly, I'd advise you not to point your finger at me. You understand? And to lower your voice. I've cautioned you and cautioned you.
Why am I the only one that has to follow the rules? Why am I the only one being obligated to follow the rules, Your Honor? Why am I the only one being forced to prove? He knows what he filed, but now I have to prove what he filed, and I've got to prove what she filed, and I've got to prove what I filed. Why am I the only one that has to prove that I did something? And they don't have to prove that they did it. They can make an assertion, and if I don't prove that they didn't do it, then I don't understand. How is this fair? All they have to do is deny something, and it's okay with you. How is that fair? And if I deny something, I have to prove it. What's your next question, Mr. Harrington?
There we go. It gets worse, it gets better, it gets worse, it gets better. There is no dull moments in this. It is constant. It is constantly getting better and better and better. And while we're watching this, I'm going to supply you with the craziest facts of the backstory, which I don't even know how to describe. I mean, it's just so, so bad. So, I hope to see you on Monday. I'm going to start as soon as Judge Fleischer's docket is over. Go watch that on American Courts. He's going to have it live. And then once that's over, come over here. You won't regret it. It'll be so good. Thanks for watching my preview, guys. I'll see you soon. Bye.